Our last case today is In Re JM. I'll just state for the record that while we've allocated 20 minutes to a side, if we're still asking questions, you may exceed your time. And any such time will not cut into rebuttal time. Now, that means that inevitably, at the end of the day here, one side will have had more face time than the other. But that's not a reflection of how we view the merits of your case. Just a matter of how many questions we had about your issues. With that, let me ask counsel to enter your appearances.
William Russell for the minor JM.
Mr. Russell, welcome. Good to have you with us and your colleagues.
Thank you, Your Honor.
And Jeff Mann, and with me is Connor Nelson for the state of Utah.
Welcome to you as well. Let's begin.
Mr. Chief Justice, Associate Justices, may it please the court, William Russell for the minor JM. For decades, non-judicial adjustment agreements, commonly called NJs, have been the cornerstone diversion process within Utah's juvenile courts. Under our juvenile code, delinquency cases are deemed civil proceedings that recognize the cognitive and developmental realities of adolescence. It is a system specifically designed to balance accountability with reasonable leeway for mistakes and learning. It seeks to craft dispositional orders akin to sentencing orders in the adult courts based upon individualized risk and need. This is not an adult criminal justice system. It is fundamentally and inherently different. The Utah legislature purposefully crafted its statutes with an eye to the uniqueness of this system and the youth who interface with it. Accordingly, in 2017, the Utah legislature instituted a comprehensive paradigm for non-judicial adjustments. It is informed by evidence-based practices and research that takes into account the intrinsic harms of formal processing for lower-risk youth and emphasizes the need to match system involvement with varying levels of criminogenic risk. These reforms are grounded in empirical evidence and policy considerations. They are a thoughtful, advised codification of the uniqueness of the juvenile system. As a result, all referrals are first reviewed by probation within the judicial branch, an impartial institutional agent of that judicial branch. Certain referrals can then be sent for prosecutorial review, a process triggered by specific and enumerated circumstances under sections 80-6, 303.5 and 304.5. System involvement is driven by a youth's risk level. Probation's determination of a risk level through a validated assessment during a preliminary inquiry is set forth in both statute and rule and is grounded in separation of powers principles. Probation does not function as an agent of the executive branch. The state suggests that they do, performing a function something akin to a combined police officer and prosecuting attorney. We urge the court to find that that is an inappropriate classification of the probation officer's duty under our statute and rule.
I understand what the statutes and the rules say a probation officer can do and when they can refer it to the prosecutor. That all seems very clear to me. But what I can't find in the statutes is anything saying that a district attorney cannot independently file a petition against a juvenile when it's appropriate. So in other words, if a referral is made to the probation officer, we have all of this structure about what can happen. But can you point to anything in the statutes that say that if a referral is made to the probation office, that strips the district attorney of any ability to act independently to file a petition if they deem it appropriate?
Yes, Your Honor, and that brings up how we believe that this Bordenkircher holding that the court below relied on, the very broad discretion of prosecution to file and prosecute, how that holding is actually an opposite to what the legislature has done with the prosecutorial authority within the juvenile court, which leads us to an assertion that the legislature codified that broad discretion to file to adult prosecutors. And the state cites to the adult statute mistakenly under 17-18A-401 in its brief at page 46, when they should have cited the specific prosecutorial grant of authority in the juvenile section, which is 404. That section 404, which was enacted by the legislature in 2018 after the recodification of the non-judicial process. Section 404, and again, everything's been renumbered, Your Honor. We have another renumbering nightmare going on, but the state refers to 17-8A-401 in their brief. We submit that the proper and appropriate statute is actually the juvenile statute at 17-18a-404. And under 404, you can see that the two statutes are very different in their grants of prosecutorial authority, adult vis-a-vis juvenile. The juvenile version imposes significant limitations on that authority. And in fact, under 404, it specifically circumscribes the authority to review and prosecute juvenile referrals. It specifically limits the review in accord with Title 80, Chapter 6, which is where both 303.5 and 304.5 reside. So a citation to Bordenkircher is not only unhelpful, it is inapposite simply because the legislature has acted to limit the prosecutorial discretion specifically in juvenile prosecutions.
Okay, so let me give you a hypothetical. There's a mass shooting at a public event. It turns out that, and multiple people are killed. It turns out that the suspect is a juvenile. Under our statutes as they currently stand, the DA cannot file a petition with the court. They have to wait until the matter is referred to a probation officer who then would, only under this framework, could then refer it to the DA's office?
Your Honor, under the current statute and practice, the referral would need to, the youth is going to be in custody on a case such as this. If they're not, there'll be a warrant for them, Your Honor. But if they're in custody, then the referral is required to go to the juvenile probation department, which, seeing that there are multiple felony offenses, is going to make a clear and expedient determination to give that to the prosecutor immediately. And that does happen regularly, where serious offenses are channeled by law enforcement to juvenile probation, who then sees these are all felonies. It goes straight to the prosecutor.
Okay, so let's say they make a mistake, and for some reason it doesn't get channeled to the prosecutor. The DA is powerless to charge that crime?
Probation, it's hard to conceive that in an aggravated case like that probation and its supervisors would make that type of an error, Your Honor. I just don't see that as happening realistically, where that's not recognized as a felony. The statute does not envision that type of mistake being remedied by the prosecutor. We would agree.
Okay, so let me give you another hypothetical. We have a bank robbery and it involves 3 people, one of whom is the getaway driver. The police investigate it. They're referring it to the prosecutor's office. The prosecutor is planning to charge it and then realizes that the getaway driver is a minor. Does the DA's office have to stop what they're doing and wait for the police to refer that to the probation officer, who then has to refer it back to the DA?
Your Honor, in that case, because of the broad definition of who may make a referral, the prosecuting attorney could notify and make their own referral. And again, in cases like this, these youth and adults are all in custody at this time, Your Honor. But they could make that referral to probation and say, this is obviously a felony. we're looking at filing. So that communication could happen within the statute because the prosecutor, unlike in this case, could make a referral to juvenile probation with the designation, this is clearly a felony, we intend to file, here's your notice, and here's the referral under the statute. That's how that would be remedied in a fairly expeditious manner in our experience.
Okay, so tell me, I understand how it works in practice. What statute would prohibit the district attorney's office from just filing a petition without making a referral to probation?
The statute, in the definition portion of the statute, Your Honor, at 80-1-102, 80-2-102, I believe, it specifically lists that referrals must be made through probation. It's 80-6-102. Both 11 and 14, under the current statutory scheme, require that a formal referral means a written report from a peace officer or other person informing the juvenile court that a minor committed offense within the jurisdiction of the court. So that statutory language locks in the referral as being required to be submitted by law enforcement or any other person to the juvenile court to make an initial determination. Now, I agree with Your Honor's assessment that it's clear what the initial determination is, but the statutory scheme does require a referral to the juvenile court in order for the referral to come into their system.
And I apologize, I'm so mixed up by all the numbering changes. So are we looking at the statute that is titled referral to the juvenile court and starts as except as provided in subsections 2 and 3?
Your Honor, I was referring to the definition section in
Okay.
6102.
Okay.
But are you referring to 303.5, Your Honor?
Well, the one I'm looking at right now says it's 301.
Before you go to 301, can you just
Yeah.
tell me what subparts of 102 you were just referring to, just a
The
minute ago?
subparts of 102, Your Honor?
Yes.
That's 11 and 14.
Okay, thank you.
That's the definitional section that requires submission to the juvenile court.
So yes, I'm looking at 301. Because I think 303.5 is interesting because it starts out as if the juvenile court receives a referral. So that seems like we're a step further, right? We're at where the juvenile court receives a referral. So 301, I'm looking at, and it says, except as provided below, it says, an official shall file a formal referral with the juvenile court within 10 days after the day on which a minor is taken into temporary custody. I'm trying to figure out if the shall goes to filing a formal referral, or if the shall goes to, it has to be, if a formal referral is filed, it has to be done within 10 days. Do you understand?
I think I do, Your Honor. And the 10-day period is only activated when the minor's taken into temporary custody, which doesn't happen all the time. But our position is, as Your Honor's pointed out, that shall file a formal referral, which by rule is determined to be a written referral provided to the juvenile court, that shall file a formal referral does mesh with the other statutes that say it has to start with probation. The referral has to start with a submission to the juvenile court. So our reading of 301, Your Honor, does lead us to assert that shall file a formal referral within 10 days if they're in temporary custody. Now, on the citations, because law enforcement can refer on citation for minor offenses, Your Honor, that's not a temporary custody situation. That's outside of the 10-day limit. But if the minor's taken into custody, the legislature has deemed it provident to say, let's get this done in 10 days. It has to go to the judicial branch through the probation department so that they can make an initial determination. And if it's listed as a felony, it's gone to the prosecutor for their filing and screening.
Who decides whether it will be listed as a felony or a misdemeanor? How does that label get attached?
Justice Peterson, it's our position that under the statute that law enforcement does an investigation. They determine what facts are yielded in that investigation. And based upon those facts, law enforcement makes a determination under our scheme that the facts that we've worn out support a referral, for a Class A misdemeanor, as in this case, or as a felony, as in other cases, Your Honor. So law enforcement has been entrusted by our legislature to make that determination after their own investigation, as the law enforcement did in this case. And then at that point, it's turned over to probation to do their function, which is completely different, which is to look at the prior record of the youth, set up a preliminary inquiry, do a risk assessment, and then determine whether there are any preclusive factors to offering that youth an NJ. So under our scheme, it's law enforcement that makes that determination, which is supported by the language of multiple statutes that we referred to in our briefing.
Can you say again the number of the statute that defines the prosecutor's authority in juvenile cases?
I'm glad to, Your Honor. Because of renumbering, it's going to be difficult. So matching it to the numbering in the state's brief, the juvenile prosecutorial authority is 17-18a-404. I believe that under the recodification, I'm going from memory now, Your Honor, it is now 17-68-505.
Thank you.
And I think I can confirm that, Your Honor. I cannot. I believe that's the citation, Your Honor, to the current code.
Thank you.
I realize that this case, you've said does not involve any continued investigation or any more development of the facts. But if we assume that you're correct, that the probation officer has to go with whatever is referred, right? If it's a misdemeanor by the officer. What does happen when there is additional investigation and it's discovered that this actually is a felony? What is the process for getting it before the DA, or is it just set in stone that once the referral is made, it's set in stone?
Your Honor, we do not believe there is an avenue under the statute to redress that, but there are other avenues available to redress errors that are made systemically. First of all, Your Honor, under the non-judicial, there was in this case, and there can be victim offender mediation, referral to counseling, community service, any number of interventions that include restitution to make the victim whole. So those are a part of the non-judicial. But for errors within the system, there are three alternatives that we see, Your Honor, that not provided by the current statute, as you pointed out. There is training by local prosecutors and law enforcement, both at the post level before the certification, the continuing certification in post, as well as in-service trainings by local prosecutors with local law enforcement agencies, which are done and can be done unlimited, because those are the local agencies responsible for referral, for investigation and referral to the court. The second would be a more direct contact by email, voice conversation, or in-person appointment between law enforcement and a prosecutor in the screening process to say, hey, I've got this DUI here, not NJ available, and I don't know whether to refer it as a DUI or whether to refer it as an alcohol-restricted driver, which is NJ available, Your Honor. And that dialogue could ferret out some of these issues before the referral is made to the court, because once the referral is made under our statute, it does appear, to use your term, carved in stone. There is no judicial safety valve for that. The other way, Your Honor, is for the legislature to change the statute. But there are safety valves involved in the statutory scheme that do allow mistakes that have been made to be remedied. And one of those is once this prosecutorial discretion has been invoked by probation referring it to the prosecutor for a review, the prosecutor has virtually unlimited authority to do three things. They can look at the referral and say, no, this case needs prosecution. We're filing and we're litigating this case in court. Two, they can say, well, you know, it's probably not provable as a excludable offense, but it's a minor offense, let's send it back for another NJ. They've got that element of discretion. And the third element of discretion they've got is to say, you know what, there's a bad search where we can't prove this element, we're dismissing this referral and this case is over. So prosecutorial authority is invoked once probation refers the matter to the prosecution for review under the statute.
Isn't it a little troubling under separation of powers that a member of the judicial branch can make the determination of whether the prosecutor can even screen something for filing?
There are we believe that the strictness of those conditions based upon the designated offense and the referral, Your Honor, the risk level as determined by a assessment and the prior history of the juvenile. If the juvenile comes out low risk, they have no prior adjudications, this is a first offense as in this case, and the law enforcement officer, a professional who's trained to investigate, find the facts, and find the law that matches it, that the legislature has deferred to those two entities, one in the executive branch with law enforcement and one in the judicial branch as an expert in juvenile justice to administer these tests and make those determinations based upon the designated referral from law enforcement. I do not see it as troubling, Your Honor. What I do see it as is a way for diversions to be a daily function of the juvenile court, to keep these low-risk youth out of court, to make sure that they do not increase their risk level, that they are not given services that are unnecessary, to preserve services within the system, to give them a meaningful consequence quickly in order to get them right on track, to start making better choices, to give them a consequence, and to move forward based upon their risk level with appropriate programming. Only the judicial branch in the body of the probation officer has the ability to do those assessments, has access to those services, to get these important services to these youth and their families on a more immediate basis, as opposed to prolonged litigation in the juvenile court. I just think about the conversation that must have happened when JM's mom got served with a summons saying, "You have to be in court." I mean, she must have confronted her daughter and said, "How can we be going to court? I thought you did everything." And JM says, "I did do everything. I did my community service hours early. I stayed in touch with my probation officer. I did everything they wanted."
She didn't do everything, right? She didn't pay restitution, for example. But even that aside, I do have another question following up on Justice Hagan's questions. So we often apply contract principles in plea bargaining, and this is a non-judicial adjustment is a diversion of sorts, and they are not available if it involves a felony, right?
If the stated offense is listed as a felony, they do not apply. They are not,
Okay,
they're
so-
exempt.
So why would this not be voidable or void or voidable? Because it involved felony.
Your Honor, we do not agree that it involved a felony because under the statute, the emphasis is on what the referral lists the offense as, which I've referred to as the determination of law enforcement. We do not consider.
That's what the juvenile court thought, but I think the juvenile court was wrong on that. Because on page 7 of its decision, it interpreted section, I think it's 303.5, as requiring that the referral be for a misdemeanor, not that in fact it be a misdemeanor. But the statute says if the minor is referred for an offense that is a misdemeanor, and the offense here was not in fact a misdemeanor, and they are not eligible if it involves a felony offense. Not appears to be, but one that actually is a felony.
Your Honor, a couple of points. First of all, as to the restitution, JM agreed to do any restitution as claimed, but there was no claim for restitution made at this time the state filed its petition. We do not agree that this is clearly a felony offense or that it's appropriate to make an after-the-fact determination a year or a year and a half after the offenses and the investigation is over. The determination of a misdemeanor was made by the investigating officer back in 2024, and the probation officer had to make a decision as to whether this youth was eligible for a non-diversion back in that same time period in late 2024. Your Honor, you brought up this mistake and who bears the risk of this mistake. We would assert that the holding in the State versus Patients by the Court of Appeals is instructive in who should bear the risk of any error. We don't know that there was an error. We think that the police officer did his job and probation did their job, and that this after-the-fact redetermination or reinvestigation of the facts is not really germane to the statutory scheme and the determinations made in 2024. But the holding in Patience states as follows, quote, "The state must be deemed to know the law it is enforcing. Thus, the state bears the risk of the mistake at the time the parties entered into agreement." Now, entered into the agreement. Now, we would assert that if this axiom applies in an adult court plea bargain, like it did in Patience, then a fortiori, as to the agreement between a state agent and a 15-year-old child, on her first ever referral to juvenile court, the state has to be bound by the agreements of their actors, and because they are deemed to know the law, they must be held to their bond, that they've done their due diligence and determination, as we believe law enforcement and probation did, and that agreement, if there's any risk of a mistake, it falls on the side of the state. Again, our 15-year-old did everything, to your point, Justice Nielsen, everything that was asked of her, she did in a timely manner. She met with probation, she signed the agreement, she performed the agreement, her part of the agreement, and she was kept in contact with probation as she was required to. And at the end of it, when the filing took place, no restitution amount had been claimed. Therefore, here we are nearly 2 years later, and we have to ask ourselves, did this make sense? Did any of this, was it driven by principles of equity and fairness? And is this the result the legislature would have intended? Because of the unfortunate and chaotic result, it's our position that no, it doesn't make sense at all to go through this process and then give the state the ability to swoop in and abrogate this agreement that a 15-year-old made with an agent of the state. No, it absolutely, it is devoid of principles of equity and fairness because of the situation that the 15-year-old is now in. And third, it does not seem like the legislature intended for a chaotic and unfortunate event such as this has turned into to be part of their legislative intent. And therefore, we ask this court to reverse the judgment below.
Thank you, Mr. Russell. Mr. Mayor.
Good morning. Might it please the court, Jeff Mann on behalf of the state. The juvenile statutes we've been talking about today delineate two kinds of authority. One is authority that prosecutors have, one is authority that probation officers have. And I think it's important for us to understand what the limits of those authority are in order to understand whether what happened here was appropriate and lawful under the statute. It's a state position that the non-judicial adjustment was not authorized, it was illegal, and therefore the prosecutor had the authority to file a petition. Justice Hagan asked a question towards the beginning about the prosecutor's general authority over all of these cases. If we look at section 80-6-305, gives prosecutors statutory authority to file petitions in almost all juvenile cases. It specifically carves out cases that are when the juvenile is under 12 years old. This is 80-6-305-1. A prosecuting attorney shall file a petition in cases that to commence a proceeding against a minor for adjudication except as provided in these certain things. One is when the juvenile is under 12 years old, and unless it's a murder or something major, when it's started by a citation under 80-6-302, or these next two sections, 502 and 503, or as if they're charged as an adult in adult court. So that's the general authority to file a petition in all cases. The non-judicial adjustment is a small carve-out for when cases are low-level misdemeanor offenses, do not involve a felony, then these cases can go to juvenile probation for that purpose. But critically, 304.5 states that if a prosecutor has statutory authority to to file a petition. This is 304.5, number 5. A prosecuting attorney may not file a petition unless, so they can if they have statutory authority, which is the statute I just went over, and the minor is not eligible for a non-judicial adjustment. So the critical question here is, was the minor eligible for a non-judicial adjustment? If she is, then probation is authorized to offer that non-judicial adjustment. If she's not, then the prosecutor is authorized to file a petition.
Okay, so what is your response to the argument that whether the juvenile is eligible for a non-judicial adjustment is set in stone when the referral comes from the law enforcement? So that is what determines whatever the police officer put in the referral, what level of offense it is, that part the probation officer can't change. And so if their argument is correct, then wouldn't that mean that the minor is eligible for a non-judicial adjustment under this section?
I believe you're correct. If it were set in stone that a law enforcement officer gets to make that determination, and and the probation officer, even if he notices a mistake, can't do anything about it, prosecuting attorney notices a mistake, can't do anything about it, then we've got a serious problem. But I don't think the statute allows that at all. First of all, a formal referral by definition, and my friend on the other side only read part of it. This is 80-6-102, subpart 11. A formal referral means a written report from a peace officer or other person. Okay? There's another part of the statute, that's Rule 14A. A law enforcement officer or any other person having knowledge of a reason to believe facts would bring a minor under the court's jurisdiction. There's other parts of the statute that talk specifically about school officials, principals, teachers. According to what this definition is, my neighbor could be upset with my teenagers for running across their lawn and file a formal referral. They are any other person, they can do that. We cannot possibly allow an ordinary citizen to set in stone what happens with the juvenile. It just makes no sense at all.
But then, so what would happen though? Let's say it's your neighbor. And that referral would go to juvenile probation, right?
That's a great
Do they all
question.
go to juvenile probation?
Returning again to the definition of formal referral in 102, part 11, it's this written report. In subpart B, it says that a minor's case must be reviewed by a juvenile probation officer or a prosecuting attorney. So there's no requirement that only juvenile probation can look at these. Prosecutors can do it as well.
Okay,
And
so that goes to my hypothetical that I was asking earlier. There's a mass shooting, the juvenile is the suspect. Does that have to be referred to juvenile probation, even though everyone knows that it's not eligible for non-judicial adjustment, or can the prosecutor just proceed?
I believe a prosecutor can proceed because they have authority under, and the statute that I referred to earlier, 305, talks about a prosecuting attorney shall file a petition in accordance with Rules of Juvenile Procedure Rule 17, which lists all the process of filing petitions in juvenile cases. If a case begins, take your bank robbery one, for example, we've got adults and juveniles all scooped up together. If a case begins there and it goes to the prosecutors, there's no reason, there's nothing in the statute that requires that the referral be done in this certain way. And then I would also add that even if it were, the referral, again, we talked about any other person can do it, even 301, 86-301, talks about a peace officer or other public official of the state, county, or city. So the prosecutor themselves can start the referral based on something. And if it's obviously it's a felony, if it's a bank robbery, if it's a mass shooting, there's no reason for juvenile probation to get involved.
So when there's a referral, it can go either to the prosecutor or juvenile probation.
That's correct, under the statute. Now, I think a big part of the question here, and some things that my friend on the other side are talking about, is what's the actual procedures that go on behind the scenes, right? And I can't speak to that because I'm not involved. But there's nothing in this statute that says we have to enforce unauthorized non-judicial adjustments because a peace officer made a mistake in what they put on the cover of their
If
document.
the referral goes to the prosecuting attorney or the prosecutor's office? What do they do? Do they also screen it to see if it's potentially could be a non-judicial adjustment?
Absolutely. Whether they start with it or whether it's sent to them by juvenile probation, as my friend said, there are three options. They can file a petition, they can send it back for non-judicial if they think that's the best course, or they can dismiss the case. But nothing in here takes away the probation or the prosecutor's office's authority to file petitions in appropriate cases, which includes when they're not eligible for a non-judicial adjustment.
I guess the thing that is somewhat confusing to me, though, is it seems to allow a referral from anybody to go to juvenile probation, who then analyzes whether it's a proper, subject for an NJA. And then it says the prosecution can't file a petition for something that's eligible for a non-judicial adjustment. And so pursuant to the statute, one way for that to be determined has happened under a statutory process. And it seems like if they weren't allowed to do that, they wouldn't be able to screen for that before it ever went to the prosecutor. Does that make sense? So they're given the authority to make a determination about whether it's a non-judicial adjustment.
They have very limited authority to, in addition to checking how many prior non-judicials and things like that are in the statute. But ultimately, it comes down to what offenses are we dealing with here, okay? And if it's, I think the intent, right? I mean, clearly the intent is felonies don't go through non-judicial adjustments. I think we can all agree upon that. So the question then becomes, what happens if the juvenile probation doesn't know what to do? And I think that's why, at least the original rule, the rule that was in effect at the time, 14A, says that the intake officer shall make a preliminary determination with the assistance of a prosecuting attorney. If there's any question that this might involve a felony, you talk to the prosecutor, you have them review it, you get their input. You don't say, well, even though I read this report and it identifies 2 felonies against 2 different people, one of which had a broken rib, plus the officer has essentially quoted the language from the riot statute, I'm going to ignore all of that and say, well, it just says assault on the cover, so that's all I can do. That doesn't make any sense. And that really, if we're talking about a preliminary inquiry means I'm going to ask questions, I'm going to think about this. Not, it says assault, that must be a Class B, we're done.
And that doesn't seem so crazy to me. I mean, I think that is what the statute is saying the probation officer does. What perhaps seems like the mistake is made in the cop's mistake, right? If this is so confusing and uncertain, why don't we put the burden on the officer to talk to the prosecuting attorney to make sure he's putting the right information on that form? But it feels like once he does that and it goes to probation, probation does have a very limited responsibility. And I think if we were to accept that he should have done more here, you'd be expanding a role within the judiciary that just doesn't seem at all appropriate to me. And I don't think the way it's outlined in the statute. The investigation, I think, is supposed to go to what the record is of the juvenile primarily, and just to confirm it's either a misdemeanor or a felony. And, that's why I think the district court for sure got things wrong in the sense that there should have been some greater investigation going on. But I just don't know why we don't say, if the investigating officer has the obligation to make sure that person gets it right.
So I guess part of this question goes ultimately to what is the referral and what does it mean to involve a felony and what does it mean to do a preliminary inquiry? If the referral, if the only thing that's in there is a 1-sheet piece of paper that says from the officer, this is a Class B assault, I'm done. Maybe we probably have a different situation here. But the definition is a written report. This is the police report. And if you look at it, there's 3 crimes identified. So regardless of what's on the cover page, there are 3 crimes clearly identified in this written report. And juvenile probation shouldn't be able to put up blinders because if we're talking about equity and what's right for the child, the legislature has determined if there's felonies involved, equity is we make sure this juvenile goes through this other process. And we make sure all these victims are accounted for. Not we just put up blinders and, just assume everything is grand because there's the word assault is on the cover page of
So
the
you
document.
think the probation officer does have to do both a factual and legal assessment of what crime should have been referred?
I think at a minimum, they need to read the entire report and determine whether or not that report involves a felony.
So yes.
So yes.
So if
that-
it's a very, like you might have, say there was just one crime here, and the question of whether it caused substantial harm or not is not obvious from the facts. You could argue whether it did or didn't. What's the probation officer supposed to do in that situation?
they
Make
seek-
its own independent judgment about whether this really qualifies as a felony, even if referred as a misdemeanor?
If there are any questions about whether it involves in a felony, it should go to the prosecutor, who can then review it, and then, as I said, they can always send it back. But that's the safety valve, if you will. Not prosecutor, I don't really, or probation, I don't really know. It might be a misdemeanor, so I'm just going to do that, even though I might not be authorized to do that. That
But
can't be the way
why
it's
should
supposed to
that,
work.
why should that be on the probation officer? I mean, I understood your larger argument to be that the prosecutor can make an independent determination on these. So I'm just wondering why we're putting it on, or you're suggesting that it should be put on the probation officer to assess whether this is a felony or a misdemeanor. Why isn't that just on the prosecutor? That if the DA's office believes that this is a felony, then they can do what they did in this case, which is file a petition. They don't need to wait for the probation officer to refer it to them.
Yes, I agree with you, Justice Hagan, that they can do that. I guess I was answering a question is, what is the probation officer's role? And that's what their role is they look and see if it involves a felony. But at the same time, if the prosecution, under their authority, they can file petitions, they can determine that they're not eligible, that the juvenile's not eligible, and then they can file a petition. So there's a little bit of.
Right, I mean, I'm guessing there are a lot of, I mean, even the enhancement for multiple people being involved. There are a lot of things that might not be obvious to either the officer or to the probation officer about how to classify this particular offense.
Correct.
That is traditionally a prosecutor's job to determine. So I just, that's why I don't know if it's so much that the probation officer has an obligation to refer it to the prosecutor if there's any question, versus the prosecutor can independently make a determination.
Yes, so I think what might be helpful, and I think I understand this correctly, and I apologize that this may not fully be in the record, but procedurally, the way this works is when the referral is filed, I believe both the prosecuting office and the probation office can look at it and can view it. So I think that's how it could happen, that it's kind of both ends simultaneously.
And I
could be
assume
viewing
that
it.
a victim could complain to the DA's office, or, there could be further investigation. I'm sure there's lots of ways it could come to the attention of the DA's office.
Correct. And I think another important point to point out here is that this referral, according to 301, in some cases, it has to be filed within 24 hours. We might know very little about what all the facts are and what's all involved in this case. And if we are limiting what can happen based on what a peace officer might understand within 24 hours of a crime, then a lot of things are going to fall through the cracks, and that can't possibly be how this should play out.
Well, it seems like it shouldn't, but it kind of seems like the statute sets up that process.
But
So
again-
I totally agree that deciding what the appropriate charge is the specialty of prosecutors.
Correct.
You get a ball of facts. This is what happened, and the prosecutor is the specialist at looking at that conduct and figuring out how that maps onto specific charges and whether it's a misdemeanor and a felony. So it seems like it would be reasonable to have a process where any referral goes to some sort of intake or screening with the appropriate DA's office, and they make an initial determination about whether we've got a misdemeanor or a felony or whatever, but they haven't set up the process that way. It seems like some referrals just could go to the prosecutor's office, but also maybe wouldn't. And so I hear you that seems to make the most sense, but it doesn't seem like that's the system that was set up in the statute.
Well, I'll again identify the definition of formal referral. It can be reviewed by both probation or prosecutors.
Okay.
Again, prosecutors have authority to file petitions in virtually all cases if they're not eligible for a non-judicial adjustment, and they can make that independent determination themselves.
And, okay, that's where I'm wondering, like, where does it say they can make that independent determination? So if a referral doesn't go to them, and it seems like it's a little bit of happenstance, it could be a neighbor, it could have been the teacher who sees this fight and the police don't show up and the teacher makes a referral. And it seems to be happenstance whether they decide, I'm gonna go to the prosecutor's office or I'm going to just refer it to judicial probation. So if something's not referred to the prosecutor's office, what makes clear that, no, they can still make an independent determination that it should not have qualified for a non-judicial adjustment?
It's 305, Your Honor. The prosecuting attorney shall file a petition to commence a proceeding against a minor for adjudication of alleged offense. And the limitations on that in 304 is if the minor is, or not limitation, but addition to that, if the minor is not eligible for a non-judicial adjustment. So nothing anywhere says a prosecutor can't look at anything only unless juvenile probation tells them to. There's nothing in the statute that says that. Rather, the statute says prosecutors have this overall authority to file petitions in appropriate cases.
Counsel, you referenced equity earlier. How should equity figure into our assessment of the contract that was reached between the juvenile and the what? And the probation officer?
Correct, the juvenile and
The
probation.
probation officer. I mean, as it has been noted, she entered into a contract with an officer of the state. She relied upon that. She sought to fulfill that. She did not pay restitution, but apparently none was asked of her.
That would have come, it was open for about 2 more months after this all kind of got short-circuited.
Had she expressed a willingness to pay, has she agreed to pay restitution?
She agreed to pay it, and it hadn't yet been fully calculated yet.
So should we be looking at equitable principles at this point, or how should we approach that analysis?
Yeah, a couple of responses to that. First is, it wasn't until the reply brief that the defendant has raised these contract principles that need to be applied, and so we haven't really had a fair response to that. So I think it's waived. But even the response I can give to you, that if my friend said that the state bears the burden of risk, state typically means the prosecutor, and the prosecutor wasn't involved with that agreement at all. So it's hard to say on the one hand that juvenile probation is this, they're the judiciary, they're not the executive, but the executive is bound by that agreement, especially when that agreement is illegal and unauthorized under the statute. We don't bind parties to illegal contracts.
Can even one DA's office bind another DA's office? My practice experience was in federal court, but one U.S. attorney's office could not bind another U.S. attorney's office by a plea agreement without their consent. I'm just curious. Do you know the answer to that?
I don't know how to answer that, but
Okay, no
it
problem.
would seem, if it's a case that kind of involves multiple jurisdictions and multiple county attorneys' offices, that one couldn't do it all on their own without consulting with the other and resolving the case.
That's why it would surprise me if an officer of the judicial branch could bind a DA's office at all, even if one DA's office can't bind another one.
Correct. Yeah, to not only bind them by not being of the same judicial branch, but based on allegations made by a peace officer in 24 hours before everything's been decided, and then stripping the prosecutors of their authority in the statute to file petitions where appropriate. So ultimately, I think this comes down to, was this non-judicial adjustment authorized by statute? It's the state's position that it was not, because that referral, which the defendant stipulated to in our motion to supplement, the referral is the entire police report. It clearly involves at least 1, if not 3 felonies. That non-judicial adjustment was not allowed, and the prosecutor had authority to file a petition.
Can I just get the state's position on one thing? Earlier, I was giving the example of when something was so clearly a felony and was clearly going to be charged by the DA's office, whether a referral even had to be made. I realize that's not this case, a referral was made, so in this case, we're looking at, even if a referral is made, can the prosecutor act independently? But I'm just curious what your position is on whether a referral has to be made, because under 301, it does talk about a peace officer or public official or shall file a formal referral with the juvenile court within 10 days when a minor is taken into temporary custody. So I'm just curious, what is your position on that? Does a formal referral have to be made to probation regardless of whether the DA intends to proceed with a petition?
I think ultimately the purpose of the referral, and again, looking at the definition, it's to inform the juvenile court that there's a case within its jurisdiction.
Okay.
So even if the prosecutor gets everything first, we still need to somehow tell the juvenile court that they've got jurisdiction over this case. And so again, according to the definition, the prosecutor himself could file the referral, but then also be the one who's reviewing it, says, obviously this is a felony, we're not doing a non-judicial, and we're going to file a petition. So I think it can get there in that way. There's also citations, and I don't know if there are other statutes about other ways that cases might begin, but ultimately there's something that has to alert the juvenile court that they have jurisdiction over the matter.
Can I ask a quick question about 305 and whether or not subsection 1 there is vesting the prosecutor with authority, or if 305 is just simply a procedural type statute where it's saying if you want to start these kind of cases, you have to file a petition, where the exceptions seem to be when they don't have to file a petition and they file something else or don't need to do that at all. And so I'm just to start a case. So I'm just wondering if we should read 305.1 as actually vesting prosecutors with authority to file petitions in cases involving juveniles, or if it's really something more about when a petition has to be filed to start a proceeding.
I view it as vesting them with authority, right? A prosecuting attorney shall file a petition to commence a proceeding
In
against a
accordance with
minor.
rules of
Right, and-
procedure
right.
to commence a proceeding, and then here's the exceptions for when you have to file the petition. That feels very kind of like, here's how you have to start it if you're going to do it, not here's your authority to do it.
I don't know whether it can't be both.
Okay.
And I don't know what other statute might give them authority over juvenile cases if we're not talking about this one, right? My friend mentioned a 17-something that wasn't in any of the briefs, so I haven't really had a chance to look at that yet.
Right.
But ultimately, this 305 is the most broad. Prosecutors, you have authority to file petitions in all of these cases, including when a non-judicial adjustment is not authorized.
Okay.
And that's the case that we have here.
I have just one more question.
Happy to
I
answer.
want to make sure I understand your position on 80-6-304.5, which seems to specifically talk about when a prosecuting attorney shall review a referral to the juvenile court. And it's upon request, or if the minor doesn't comply with their non-judicial adjustment or they're not offered one. How does that cut in this case?
Sure. And I did talk about this in my brief.
Yeah.
But this is talking about, these are 3 required times for them to view it.
Okay.
But it doesn't say they may not review it in any other circumstance. Obviously, the definition of formal referral, it could go to them initially and they can review it. But, you know, what we're talking about is if it is going through this process of starting with juvenile probation, then they have to review it under these circumstances.
In 304.5, 5A and B. So that's where it specifically talks about when a prosecuting attorney may not file a petition. So they may not file a petition unless they have statutory authority and the minor is not eligible for a non-judicial adjustment. And I guess my question on that second part, 5B little 1, is according to whom, right, that they're not eligible. So could a prosecutor come in and they have discretion to review a referral and they say, oh no, this minor was not eligible. And so I can file a petition because this is something I have statutory authority to do under 5A, and I'm determining that they're not eligible.
Correct. And I think if I could just quickly, as an aside for Justice Pullman, statutory authority under 305 is what this says.
Show me where was,
Yeah,
I lost what Justice Peterson was.
304.5, 5A. So the prosecuting authority has, prosecuting attorney has statutory authority under 86-305. So I think it does give them statutory authority to file petitions.
But then it's an and.
Sure,
And they're
and not eligible. So the question is, who determines whether they're eligible? I think the answer is the legislature has determined whether they're eligible if it involves a felony. Now, I know there's a little bit of wiggle room in there. Well, who decides if it involves a felony? I think there might be other cases that are closer. This is not a close case. We have 3 identified felonies in the referral. There was a mistake. That's ultimately what we have
But at the
here.
end of the day, can't the juvenile, if a petition is filed, can't the juvenile move to dismiss the petition and have the juvenile court or determine whether this is a felony or whether it's eligible for non-judicial adjustment? I mean, isn't that the person who would ultimately decide whether it was eligible?
I think that's fair, that certainly they could argue that they were eligible and should have got that, and then we'd litigate that. And that's kind of what we have here, just kind of the reverse, right? And so that's why we have juvenile courts overseeing all this. It's under their jurisdiction, and they can be the final decision maker if the referral involves a felony. Unfortunately, the juvenile court's ruling was a little not exactly what either side believes is the right answer. But I think if we are interpreting this statute as we should, does the referral involve a felony? I think it's quite clear that it does. And so this court can then decide in the first instance that there's nothing wrong with the prosecutor exercising statutory authority to file a petition and correct an error that the legislature never intended for 3 felonies to go through a non-judicial adjustment.
Going back to Justice Peterson's question, though, I mean, in 304.55, the minor's not eligible under 303.5. And 303.5 says the probation officer is to determine whether the minor is eligible. So it seems like the answer is according to whom is just not according to, anyone who looks at it later. It's according to the probation officer,
Yeah.
who I think, at least I would feel very uncomfortable saying the probation officer is supposed to make really kind of a judgment call about whether this is a felony or not. I think that comes through the police, or the police officer.
So I think if I can answer your question with kind of an overall, again, purpose of what this statute is, my understanding is the intent of this is we take cases that are obviously misdemeanors, and we don't bother the prosecutors. We just do these quick, non-judicial, we'll make it easy. If there's any question about it that it might involve, and I think involves is also an important word here. Involves is broad, not charged with a felony, not committed a felony, involves a felony. So the probation then should look at it and say, well, we've got a riot statute cited right here in the referral, and there's this injury of a broken rib, that's a felony, or at least it might be felony. I think I should at least have a prosecutor take a look at this. So I don't have to make that judgment call, they get to, and then they can always send it back if they think that's what's most appropriate. So if we're looking at what's the purpose of allowing probation to get involved here, is to take away these obvious cases, make this go through this easy process, but if there's any question, it goes to the prosecutor, and then they can make those judgment call determinations.
Okay.
If we don't allow that type of thing to happen, then we allow juvenile probation have unchecked authority to allow unauthorized, illegal, non-judicial adjustments that they're not authorized to do, and nobody can fix it, and we're just stuck with it. And we've got bank robbers and we've got mass shootings that accidentally go through non-judicial adjustment, and nobody can fix it. And that shouldn't be the way that these statutes should be interpreted. I'm grateful for the court's questions. I ask you to affirm the juvenile court's ruling to deny the motion to dismiss the petition. Thank you.
Thank you, Mr. Mann. Mr. Russell.
Thank you again for this time. At the outset, we just want to rebut the statement that we strongly disagree with the state's characterization that these were obviously 3 felonies. It is not obvious at all to the trained law enforcement officer who investigated the case, found the facts, and determined that the injuries were more consistent with substantial bodily injury, the Class A misdemeanor, than they were with serious bodily injury, the felony. That's the determination that the police officer made after her investigation.
Why wouldn't that be ultimately a question for the juvenile court? So if the prosecutor disagrees and thinks that these are felonies and files a petition, then the juvenile brings a motion to dismiss, saying that, this is eligible for non-judicial adjustment, and the juvenile court makes that determination.
That would be a determination that would be available at trial, but this statutory scheme wants to stop it from proceeding that far, Your Honor. Because the youth is low risk and it's referred as a misdemeanor assault in the judgment of the police officer, because the legislature doesn't want the matter to proceed further, much as a justification motion in a self-defense case, because the legislature's made a determination that that has to be made on the officer's referral. We do not want the youth to be engaged in formal litigation and court proceedings when what we've got is a misdemeanor. If we were to go to trial, Your Honor, at the end of the state's case, the defense could make a motion to enter as a substantial injury Class A and then ask that it be remanded back to probation for the offering. But the statutory scheme doesn't envision that because it stops the referral process once the referral for the misdemeanor and the risk assessment comes back low. Our position is that the state's reading that the probation officer should either reinvestigate or make legal determinations about what that police report says is not justified in the statute, and it opens up a Pandora's box of duties foisted upon a juvenile probation officer that he or she is not trained to do, not qualified to do, doesn't have the legal training to do. This is simply not something that's appropriate for a probation officer to make these types of determinations.
I just wonder if it's appropriate for the police officer to make those types of determinations either.
Your Honor, I think we have to trust them. The legislature has entrusted law enforcement to find the facts, see what crimes fit it, and then refer it. If there's a training issue, the prosecutor should address that with those police officers. If the police officers have questions before they make referrals, they should address that to the local. These are in the same county, Your Honor. And on your question about whether one prosecutor can bind another prosecutor in a different county, Your Honor,
Yeah.
the case that we cite in Irvin in our briefs does state that one prosecutor does bind another prosecutor within the same state, because to breathe life into these diversion agreements, we have to have some reliance upon the state's word that their bond is something that they have to be bound by, and that a diversion in one county constitutes an agreement with the state to bar a prosecution in another county.
Thank you for having an answer on that.
Thank you, Your Honor.
So, counsel,
Yes, Your Honor.
the state charged 3 felonies, right? One was riot.
Yes.
The other was aggravated assault,
Yes, sir.
and the third was,
A simple assault.
okay, and should we be looking at this point in the process at whether those allegations are supported by the facts?
I do not believe that's an appropriate scope for this time and place, Judge. Chief Justice, I believe that was foreclosed by the determination of law enforcement. And these other methods to correct mistakes or errors that I've outlined should have been employed at that time, ideally. It is totally within my personal realm of possibility that this police officer, after her investigation, looked at this and said, you know, there's just not enough evidence to show riot, because I don't have any evidence that these 3 individuals assembled for the purpose of assaulting somebody. Riot's a pretty technical offense and involves many nuanced elements, and it's just as likely that law enforcement said it's not there as it is that they said, well, I never thought of riot. But we don't know, and in our view, this second guessing nearly 2 years after the investigation is over is not appropriate, Judge. It has been, Chief Justice, it has been foreclosed, and therefore, Your Honor, we are left with the proposition that the legislature wanted law enforcement to do their investigation, and they wanted probation to look at the record and do an assessment, and then offer the NJ. Which brings me to the point that Rule 15E prohibits the prosecutor from filing a petition if the NJ has been offered, accepted, and is being performed. Once it is closed out, which it's, as Justice Nielsen pointed out, still had some time to do, but restitution, there is no evidence that a restitution claim was ever even tendered in this case. Our client did not understand that there was any restitution requirement because none had been presented to her.
Where do you get that the statute prohibits this when a non-judicial adjustment has been offered, accepted, and partially performed?
That's Rule 15E, right? Not the statute.
Thank you.
The notion that prosecutors can just review everything, well, that puts all of the diversionary process asunder. The prosecutorial authority, as granted in the correct section of juvenile prosecutorial review authority, specifically refers to Section 304.5 as the jumping off place where prosecutors can review referrals sent to them under 3 specific conditions. If the probation officer requests review, if the juvenile fails to complete it, or if the child declines or isn't offered the non-judicial. And in this case, it was offered, accepted, and performed with all of the agreements that were in front of that youth. The amendment to Rule 14A was brought up by the state in its main argument. And the deletion of the phrase "with the assistance of the prosecuting attorney" was eliminated in December of 2024, coincidentally, same time as this was going on, November of 2024. And the minutes of the Rules Committee's discussions on why that phrase was omitted from Rule 14A illuminate what the purpose was, and that was clearly to eliminate bias, which was brought up in the minutes of that committee meeting, and to promote uniformity. A prosecutorial member of that committee specifically states that that practice should be eliminated because it causes bias and confusion, and as a result, the committee voted unanimously to remove that phrase from Rule 14 because it did not comport with the statutory scheme. Thus, Rule 14A was amended so that confusion would be eliminated and to further conform with the statute. If I may, I'm out of time.
I have one question.
Yes, Your Honor.
What part of the statute says that a prosecutor could not do what was done here? So the provision you were just talking about says when a prosecutor shall review a referral. So it's saying they have to. It doesn't say they can only do it in that situation. The language is more of a command that they shall do it in those situations. What would you point to say the prosecutor is not allowed to do it in this situation? If the prosecutor decides this is something that I have authority to file a petition for, and I think that this is a felony, so this person is not eligible, what disallows them from doing that?
Your Honor, to answer that question, I think we have to refer to the statute's determination that there needs to be some process by which probation can make the determination on their own based upon law enforcement. It's a separation of powers argument that the legislature delegates to law enforcement, do your job, make the referral, name the charge, and state the level of offense. The rule supplements that, Rule 15E supplements that by saying once the offer is made and it's accepted, upon completion, then they may not file a petition at that point. Our argument tends to be, Your Honor, that if prosecutors could jump in and undo any non-judicial agreement at any time, what do we have left? Giving the prosecutor the ability to swoop in and abrogate the agreement up until its very last day creates the potential for grave injustice, as happened here. Such unilateral 11th hour removal of the case for formal court proceedings eviscerates the legislative scheme of diversion and renders it a nullity by granting a prosecutorial veto power over every one of the thousands of non-judicial adjustment agreements coming into probation yearly. Such sweeping authority is not envisioned by the statute and is indeed specifically contraindicated by its plain language, especially for a 15-year-old child on her first referral to court that scores as a low-risk youth. Unless the court has anything further, I thank you for your time.
Can I ask just one factual question?
Your Honor.
The state suggested that they weren't sure, but that perhaps referrals that go to the juvenile court or that the DA's office also gets notice of those. Is that the case? Do you know the answer to that?
Yeah, I believe I do know the answer to
Okay.
that, and that is contrary to my experience.
Okay.
My understanding is that law enforcement either emails, I don't think they fax anymore, Your Honor. I think they email with attachments, police reports that list an offense and the county, date of birth, and date of alleged offense. That's enough for a probation officer to make their initial determination. That's what we call the referral, Your Honor, is that basic nutshell. Then probation gets that document and loads it into the care system. The care system is the juvenile court's database, right? Prosecutors have access to that, so they eventually can see that. Defense lawyers, for some reason, don't have access to that. That is protected discovery materials. So prosecutor, probation, even judicial assistants for the judges can see the police report in there. Defense lawyers cannot see it. So to say that you can send it to the prosecutor, that is not accurate in my experience, Your Honor. It's sent to probation, probation uploads it into care, then does their preliminary inquiry, and only in cases authorized by 304.5 do they ask the prosecutor to review. After a decline, after a no-show, after a high-risk youth, or after this is a felony charge, send it.
Got it. Thank you.
Thank you again.
Thank you, counsel. We appreciate the argument of all counsel, and we will take this matter under advisement. Court is adjourned.